I have the Member of Parliament for Sekondi in the studio, Andrew Japamesa. Thanks for joining me this morning.
It's always a pleasure, Roland. How are you doing today?
I'm good. I'm good. What have you been up to the last 24 hours?
Well,
you were in Parliament.
Good morning to our cherished viewers who have spent time to be with us this morning, particularly my constituents in Sekondi. Past 24 hours. Yes, I was in Parliament yesterday, and when we adjourned for the day, I had some errands to run. And, my brother also came to Ghana. We are bereaved as a family in Cape Coast. A cousin of mine, elderly cousin, has passed, so he came for the funeral. So a friend of mine picked him up from the airport because I had some media engagements to do yesterday morning. Before I went into Parliament. So
You're into football?
Yes. And my team lost, unfortunately, last night.
Manchester United.
Hardcore Manchester United fan.
Okay. So which of the transfers have you followed for you found intriguing? Because at least you bought Alexis Sanchez.
I was surprised that Aubameyang had actually moved from, I think, Dortmund to Arsenal. You know, a team that my friends who are Arsenal fans tell me that they are not interested in their Premiership.
Just because
a couple of seasons ago, when they were winning the FA Cup, they were saying to me that their interest was in winning FA Cup only. Now that they are nowhere close to winning the FA Cup and are nowhere near contention for the Premiership, I wonder what their storyline will be this time around. I hear his medical has been delayed because the doctors are examining his head, whether there's anything wrong with him, why he left.
I mean, literally.
For a team that is practically not going to win any trophies in the next foreseeable future.
Well, Dortmund was also not, I think they were almost the same.
Well, I guess.
Kind of.
Yeah.
Anyway, let's move on. The NDC, the NDC minority in Parliament, I should say, they put together a press conference yesterday. It was addressed by the minority leader, Haruna Idrisu. Is well captured on the front page of the Ghanaian Times. It says the finance minister must resign. Minority demands. We'll bring you a set of that story as our director readies the insert for you. And it says the minority in Parliament is demanding for the resignation of the finance minister, Ken Ofori-Atta, for grossly breaching constitutional and statutory laws, as well as regulations and official guidelines in the issuance of the controversial $2.25 million bond in March 2017. And, well, let's hear the minority leader, Haruna Idrisu, on the subject.
We therefore call on the Honourable Minister to do what is honourable and accept the findings of CHRAJ and bow out and resign honourable as Minister for violating the laws of Ghana pursuant to the relevant section of Act 550. The complaint was made. President Nana Danko's cronyism is now manifest. Nepotism is manifest. Members and friends in government manifest. Rather, he should take what is appropriate to ensure that he subjects the finance minister to the full rigors of the laws. He's not above the laws of Ghana like any other person. We used to serve notice that in the event that the President Nana Dankwa does not exercise appropriate judgment, will initiate an action of censorship against the minister. We in the minority feel strongly vindicated with the report. So for those of you who have read the report well, go back to it. Don't just go to opening paragraph and some decision and come to a conclusion. If there are breaches of the law itself, there are Public Financial Management Act, constitutional provisions, we are saying that all of us must uphold the laws of Ghana, including the Minister for Finance. The government and its agencies, Flagstaff House, Bank of Ghana, Securities and Exchange Commission, Public Services Commission, Head of Civil Service must take steps to curtail or eliminate the grip of enterprise and data-bound group on government businesses. They are all around. Everywhere now is enterprise and data bank. If you go to the Ministry of Finance, there are alarming numbers about it. Parliament will revisit the issue. We will appropriately, as we've stated in the report, consider other matters relevant to this business.
I think it's unfortunate that our friends in NDC are pushing for the one of the finest ministers we have, to resign. And I don't think it's going to happen because I believe that if you look at the CHRAJ report, I think it's a potential breaches. I think we should rather, focus on how to rectify or correct those issues if there were breaches at all, than to say she should resign.
These are issues of the law. They think it should be applied strictly. A minister should work in a way that engenders public confidence, and it should amount to him working per the dictates of the law.
If you say that, it is only people that are put in the driving seat that may probably get an accident with a car. If you are not a driver, you will never have an accident with a car, assuming there are opportunities for accidents. So I believe that even if he is hurt or is breaching of the law, let's look at what the situation is. It may not amount to him resigning. It may amount to we taking proactive measures to make sure it doesn't occur again, and for that reason, don't call for resignation. I think we as people, to be honest with you, he's one of the people that we should be thankful to God for getting him as one of the people driving our finances. I don't think any MP or any lawmaker will want people to disrespect the law or just go ahead and with impunity, what do you call it, don't comply with the law. But if our friends in the NDC say they're going to use that Article 82, it means they will require about 2/3 of majority of members in Parliament to be able to get which they want.
They can't count on your support.
It will never happen. I tell you, I believe it will never happen. How are they going to get it? Even simple majority, they can get it. So if that is what they are looking at, they should go for the ultimate.
If they are making allegations about the findings of CHRAJ, which in my view was not very conclusive. CHRAJ says this is an area of potential conflict of interest. It's not conclusive. It means that it could be, but they themselves are not sure. So on the basis of uncertainty, do you drag somebody and put him on the crossfire of impeachment? I'm not too sure. I've told you on countless occasions that I've not read the report, and not having read, I wouldn't want to commit myself to anything. But we have pledged to serve the country. If indeed and in truth it is found out that the finance minister has engaged in some malfeasance, then necessarily the law may have to take its course. But we are not there, and I don't live on conjectures and speculations.
Well, so I have my other guest joining me. Roxanne Nelson Dapamokpo is a member of Parliament for North Dying. Thanks for joining me, sir. South Dying.
When will you ever get it right?
Yeah. I always think you are from Pando or somewhere. All right. And thanks for joining me, sir.
It's my pleasure.
All right. And, well, if you look at the reports, it's 140 pages, I believe.
45.
Thereabout. Okay. So, but let me get your initial reactions on it.
Yes, we have clearly stated our position on the matter. We have the firm opinion that there are bases in law that should warrant the removal of the finance minister. And we are simply saying that he should do the needful and resign himself. If he fails to do that, we are asking the president to do so. We are further saying that if the president fails to do that, then we'll be forced to spring to life the procedure under Article 82 of the Constitution. Questions have been asked. I've spoken about this matter on several platforms this morning. Questions have been asked as to whether or not we have the majority, 2/3, to be able to succeed. Voting in Parliament can be by popular acclamation, and it can be by secret ballot. So I made the point that if we decide to go by secret balloting, you'll be surprised we'll have a lot of my friends on the majority side who, yes, that's the point I'm making, that you'll be surprised.
Because you surely you're never going to get me
Ejapa,
to support you in this needless quest.
Ejapa. You see, sometimes don't use English words in a manner that sometimes you do. This is not needless. We have anchored firmly our position in law. These are not things we are presuming. These are not hearsays. These are facts, hard facts, established by a constitutional body. So you don't have to say it is needless. It is not. So don't use the adjective needless. Now, so we are saying that you'll be surprised that we will receive support from other members from the majority. When we interact, they too are not happy with a lot of the things that the finance minister presently is doing. And so this will be my initial comment on this matter as they began to unfold from yesterday.
Your also subsequent reactions to
well,
this
I say needless for good reason, because Roxanne is a very good friend of mine, and I know him from way back in law practice before we became parliamentarians. I know his competencies in the law, and he knows that when he's wearing his legal hat and not wearing his political hat, he will arrive at the same conclusions that I've arrived at.
Which are what?
Because you see, look, issue of jurisdiction, okay, is fundamental in any legal proceeding. He knows that the powers that are vested CHRAJ by the Constitution under Article 218 and 284 are clear, unambiguous. It's a commission for human rights and administrative justice. It is not a court of law. It hasn't got jurisdiction in all matters. Its scope of authority is limited to the powers that are given to it by the Constitution. What is the issue? One gentleman by name Boja Jimfi or so went to CHRAJ with a specific allegation that regarding the issuance of the bond, the commissioner, the finance minister, or the Ministry of Finance had put itself in a conflict of interest situation. The commission is mandated under the Constitution, Article 284, to investigate issues of conflict of interest. So there was no objection. So the commission wrote to the finance minister. The finance minister responded and then proceeded to investigate the matter relating to the allegation that had been put before it, and then made a pronouncement clearly on the allegation that per their investigation, the allegation of conflict of interest had not been made out against the finance minister. That was clear, unequivocal. Now, CHRAJ then went ahead to make pronouncements on matters that is completely out of its scope of authority. And you know it for a fact. Yet, you sit here, and when I say that the exercise that you are embarking on is needless, you say I'm using words that I shouldn't use. You know that CHRAJ has no power, authority to make pronouncements on matters relating to the Securities and Exchange Act. Is it a human rights matter? Is the Securities and Exchange Act an administrative matter? These are technical matters that the law has given mandate over to a specific institution. So where lies the authority of CHRAJ to go into that foray in the first place? Yet, knowing what you know. Look, today it's Ken Oforiatta who is on the board. You can chop him left, right, center for your political purposes. But tomorrow it could be you or members in your fold. And my expectation is that to the extent that we are all working to enrich our constitutional jurisprudence, you would have been the ones that challenges CHRAJ in respect of findings that they've made
that are clearly out of its mandate. Yet, because the report is out there, and I'm surprised that as we speak, it has not been challenged. And I will not be surprised too, I'm coming, that steps will be taken to strike it out because they are not out of time. Okay? That an application should be made before the appropriate forum, which is the High Court, which has jurisdiction in all matters. Indeed, if this matter had gone to the High Court, nobody would have raised issues if even they had gone out of the allegation before it to make pronouncements on matters that are contained in the allegation if they find so to be legitimate. Because, like we all know, the law is in the bosom of the judge, not in CHRAJ. He knows it. Yet they organize a grand press conference, the 36th so far, since they lost.
You've been counting.
But their records, 36, 36, since they lost power, to put out matters that they clearly know and invite the president to take action.
Well, free
and says that
free speech is guaranteed.
No, I don't have a problem. I don't have a problem with free speech, and I don't have a problem with they conducting their press conferences. In fact, I guess that their mantra now is one press conference 1 week or some such thing. Okay, they can go ahead, but he cannot suggest, because he's never going to get my vote, whether public, open, or secret, to support this needless cause. Please, we shouldn't do this to ourselves. You recall, when we commenced our foray into constitutional democracy, the NPP as a party challenged decisions, institutions in court. If you look at cases that you and I studied in law school, those are the kinds of things that we do as political actors to enrich the conversation. Not this. Like the majority leader told them 2 days ago, they are beginning to be obstructionists and not opposition party. We can't do this to ourselves. We need to be serious in building our nation. You can't dwell on matters that you clearly know, as a matter of fact, have no substance whatsoever.
Well, true. Beyond the remit of law, please, somebody will say that you are being sentimental.
I'm not being sentimental. I'm being factual. And I'm speaking
beyond the subject of law and that strategy going out of its remit, etc. You're also being sentimental.
I'm not being sentimental. I'm speaking to the facts.
I know you're speaking to the facts.
Now, my brother is saying that in an attempt to investigate the issuance of the bond, the matters that CHRAJ unearthed in this report are extra jurisdictional. Is that the argument?
Well,
for instance,
we're out of the remits of
yes, that's what we call extra jurisdictional.
I'm trying to make people understand.
They are not disputing the fact that it has happened. They are only saying this.
But you're a lawyer. In the eyes of the courts, let's say, what would have been the finding of the court or the conclusion of the court?
The report has to be acted upon. That's the essence. The report.
So even if the findings that they are contained, are clearly extra jurisdictional.
You are making the argument. And I'm asking you that if, for instance, in order to establish whether or not the issuance of the bond infringe our laws, and I have enough other things, you are saying that I lack the jurisdiction to do that. But are these matters ancillary to the issuance of the bond? Are they? So that I can establish a potential case of conflict of interest or not. CHRAJ says potential. We are saying there is a case. We have cited the instances. And it is not simply the conflict of interest situations that have been established, but clear rules and regulations and laws have been breached. And you are saying that as a constitutional body, I do not have the jurisdiction to make those pronouncements, even though they have occurred.
Come on,
Ross. No.
Okay, please. Let the actors challenge the findings in the forum convenience.
Okay. So in order to bring the conversation closer to our audience or our viewers,
indeed, yes.
The substances for which perhaps, if we have to talk within the remit of the law, for which the other side of the political divide would say CHRAJ overstepped its boundaries. what will be the individual issues raised in that 140-page report of CHRAJ for you, as you cite those instances, to be giving a certain meaning to an action taken by a finance minister which are potentially conflict of interest situations for him?
Perhaps they could say, for instance, that it is not in the domain of CHRAJ to establish whether.
Yes, but let's go individually to the issues specifically.
You mean the instances?
Yeah, the instances.
That
yeah.
one, the bond as issued breached rules and regulations established by Bank of Ghana.
CHRAJ has a mandate to investigate that.
No, please. No,
I am saying these are ancillary matters. They all relate to the establishment, to establish whether or not in the issuance of the bond there's a conflict of interest situation. And you cannot establish a conflict of interest situations if you do not interrogate all the steps leading to the issuance of the bond. Because it is in considering the steps leading to the issuance of the bond that you establish whether or not the Minister of Finance, as we know him, has in any way placed himself in the conflict of interest situation. Otherwise, they would have been doing a shoddy work. So it is interrogating the various steps leading to the issuance of the bond that they have uncovered these breaches. You understand my point? So it is not sufficient to say whether or not a conflict of interest situation arises. But you are also saying that in the course of unearthing that, we have established these other breaches. And it is important that as a people we interrogate it.
But that cannot summarily be a conclusion that the finance minister then should resign.
Why? When the instances have been established.
Based on a report of a body for which a content or some sections of its findings indicates that it shouldn't have been making those conclusions.
Which sections? My brother only spoke about the possibility of that. He hasn't established it. Indeed, he is advising that an application be sent before a forum convenience for this matter to be considered. And you'll be surprised that CHRAJ, as a respondent to that application, may also state their position to defend their jurisdiction.
I remember when this very issue came up and the minority raised the concerns that it did. So I follow a number of some of your colleagues, and Justice Sremsai, he lectures at the Gimpa Law School and Law Faculty, and he said that, and I quote him here: the finding of CHRAJ points to one direction, while his decision on the finding points to the other. He also indicates that the findings do not support the decision that CHRAJ in itself has made. CHRAJ findings that the minister was in a potential conflict of interest situation shouldn't then have ended with a conclusion that the minister was not guilty of a violation of the conflict of interest rule. So it should have actually gone ahead to say that potential conflict of interest, whether or not the minister benefited, and is still conflict of interest at the same time. Now the conclusions then is that it is possible that CHRAJ findings did not reflect the actual facts, but when that happens, there's an opportunity for the minister to apply to the court to review the findings of CHRAJ. And that clearly supports the position of your colleague.
You do not review findings because you are not the finder of fact. What they could do is to strike out, like my brother correctly put it. A court cannot review the findings. A court can rather say that, yes, you have the power to look into A, B, C, D.
And not this, and not
no,
D.
but you added E. And so for doing so, you have acted ultra vires, extra jurisdiction.
And you are a legal practitioner.
Indeed.
And that then follows sanely the position of not only Mr. Andre Japamesa, but also the position of many people who argue in the public domain.
No, Sremsai's position is about the internal inconsistency.
Yeah, sure.
The establishment of a fact vis-a-vis the conclusion, because you can only draw a conclusion based on a fact.
Yeah, sure.
You have made a finding of fact, but your conclusion are at variance with that. It's not consistent. That is his argument. Ejapa is saying that he, after having considered the report, there are certain aspects that he thinks were matters that were not in the domain within the jurisdiction of CHRAJ to interrogate. And so to that extent, he is advising that a proper application be brought. I may agree that in law that is all you do. But he needs to establish, he needs to tell us which findings of fact, which matter they shall touch on that are extra jurisdictional. So that is the next step. If you make the decision to challenge, it is not sufficient to say so. But you have to establish that in finding A, B, C, D, you have added E. Where is the E?
And we all have perused the report. Now, what then do we have to do next beyond the argument that because CHRAJ, in the opinion of you and some others, overstepped its boundaries as far as in investigating this or looking into the subject, then would have to confine itself within its jurisdiction and the regulations or the laws that established it?
No, I think a judicial review application is an appropriate application to bring to seek some declarations with respect of the jurisdiction of CHRAJ and also certiorari relief to quash some of the findings that clearly were not supported. Because, for instance, CHRAJ says that the finance minister did not disclose or failed to disclose some assets that he had in respect of the Assets Declaration Act. But was that a subject for investigation? Was the finance minister given a hearing in respect of declaration of assets? So clearly,
I'll show you why.
I mean, look, if you read the report, it's not surprising that scholars, if you like, because Shremsa and Go are academics who critique some of these findings. It's mind-boggling the kind of terrain that the CHRAJ went into. I mean, I was completely shocked because the issue before it was clear. Per the petition that was submitted to CHRAJ, conflict of interest. They come to find that, in fact, and I have their finding on page 136 here. It said clearly that the issuance of the 5 and 10-year bond or the 7 and 15 years was not organized in a way to favor Ken Ofori-Atta's friends, family, associates, and business partners. There was also no evidence before the commission that there was a personal benefit to the respondent or his private businesses or other relations. Conclusive. Then after that, and this is within the mandate of CHRAJ per chapter 24 of the Constitution, okay, to investigate issues of conflict of interest of public officers. Clear, there's no dispute. But to move further beyond this and make findings that border on security trading, is CHRAJ competent to investigate those matters? That is the key issue. Yet, it is those findings that you yourself know CHRAJ no had jurisdiction to entertain that you've tabled in your 36th press conference and is inviting the president to take action on it. And I heard you say yesterday that the press conference that you did is notice to the president to act upon.
Yeah.
And that is your official means of communicating to the president your displeasure.
Indeed, yes. Unless you are saying that he hasn't heard or read. Now it's a small rebuttal. You see, when we speak of interest in a property, it can be corporeal or incorporeal. All right?
Very well.
Yes. So when my brother says that CHRAJ hasn't got the power or the mandate to look into that aspect of the report or of the investigations, I disagree. How else would they be able to establish a conflict of interest situation if they don't look into the interest that you have in some of these companies? Because the petitioner has cited those companies. And so in establishing that you have an interest in them or not, they must look into the form that you filed before the Auditor General, whether or not they constitute part of your assets.
Why should they?
Why shouldn't I? Or why shouldn't they?
Just because the petitioners claimed that you had an interest.
Yes, they must establish whether on record you have listed those companies as part of your properties.
an interest, a shareholder in a company is a property, it's an interest.
But you see, Roxanne,
You
not
understand?
to interject.
That is, hold on. That is what on the that is what on the form, on the assets declaration form, apart from landed property, you have shares in companies. They are also listed that there's a column. Hold on. There's a column where if you have an interest in a company, i.e. shares and all that, you should be able to see them.
And if that was an oversight?
How? That exactly. That is why CHRAJ is saying, having perused your assets declaration form and having established that you have interest in maybe A, B, C, D company, you have failed to disclose, even though we make a finding of fact that you have an interest in so and so company. You have not stated it. Good. So let us be very careful.
And I'm saying that if that is an oversight,
it could be rectified. I agree.
But how do you even ascertain whether it was an oversight?
All right.
When you did not examine the register of members of the institutions that you allege the man has an interest in because he did not disclose them on his asset declaration form. Are you aware whether he has divested those interests?
Indeed.
You can only find that when you examine the register of members, and you know it.
I agree.
These are the provisions of the company.
I agree.
Did they give
I don't think, no.
to provide the
Why?
members
The man
of
responded.
The company? He did not respond. Please.
Oh, please.
There was no opportunity to
he responded.
the membership.
Let's get this. We're not in the law. Now
they referred the petition to him,
listen
and he responded to his lawyers.
Let me ask this critical question.
Do.
I get the feeling, and it's just my own opinion, that, well, beyond all the subject about the concerns that you have raised, and that the position of the minority NDC in Parliament, that the finance minister then needs to resign, is just to make political capital out of perhaps the issues that CHRAJ may have looked into, which also falls beyond its boundaries or its bounds. And so you could make some political capital out of, and so could score some good points in the court of public opinion.
I disagree with that part of your question, which says
that's exactly what you are doing. You know it, please.
Nobody has established that some aspects of the finding of CHRAJ falls extra.
Okay. So for you, the minority, you're taking the whole document as what it is.
They are within until it is stated otherwise. Until it is stated.
Well, others will say you're not being truthful to yourself because you're a lawyer. You're a lawyer. You know the law that establishes CHRAJ needs to enables it to investigate what it has to.
I have just demonstrated to you.
I know the scenario that you have cited.
There is no way you will be establishing a conflict of interest situation or otherwise if you don't consider the assets of the person that is being cited. How else would you establish that? Do you understand my point?
And you establish.
I understand it perfectly.
So allow the finance minister to react.
Department.
I am not CHRAJ.
Assets declaration.
I am not CHRAJ.
And because you did not find data bank there, you say that he did not disclose his interest in data bank
fully.
Because you do not know whether he has in fact divested his interest in data bank.
Let the man speak.
But you didn't give him an opportunity to speak.
The finance minister is still in office. The report has been issued for over a month.
Jesus Christ.
So let the man respond. It is after
his lawyers or whatever.
Let him respond to the issues. If he responds to the issues, then you and I can do this interrogation. But for me, for now, you are guessing.
Take off your political hat for a second.
Now we are speaking as lawyers.
He cannot be guessing.
We are speaking as lawyers. Right now we are speaking as lawyers.
He cannot be guessing. That will not be a very good conclusion of
so until we do that, you are presuming that he has done that. Let him state so that I did so on so and so and so and so date. But this is the evidence.
The point that I'm making is that
I know you have made the point. You have made the point.
No.
You have made the point already.
Let him finish. Please. This is important. Let him finish.
You see, CHRAJ can make those findings that there has been some lack of disclosure. When you give the man an opportunity to respond that, look, I've looked at your assets declaration, you do not have data bank listed on there. For the man to say that, yes, because I have divested my interest in data bank, and that this is the register of members of data bank, which clearly shows that I've ceased to be a member of data bank. You did not give him that opportunity. Yet, you went ahead to find because you know in the public domain that he's been associated with Data Bank for the past 30 years.
So you're saying that the CHRAJ report and what it
so how did he respond to the petition?
Let me ask on it, because you see, for example, when I was going through, for example, if you go through the reports, it says wait, the report on page that'll be page 85. It says the Data Bank Financial Services Limited was established on 20th September 2016, having been incorporated, was re-registered on 20th September 2016, having been incorporated earlier in 1990. Its objectives are so and so, and shareholders are Ken Oforiatta, Kelly Gajekpo, and Data Bank Financial Holdings. Of course, we've had Angelo Oforiatta replacing Ken Oforiatta and Kelly Gajekpo as directors of this company. And Oforiatta reassigned as director on 29th of April 2015. The commission finds as fact from above that Ventures and Acquisitions Limited holds shares in Databank Asset Management Services Limited, which in turn is sole shareholder of Databank Act Fund Limited and Databank Money Market Fund Limited.
I don't have a problem with the findings.
Great.
I'm asking, my point is this, that
Great.
when you were conducting your... No,
I wasn't... Oh, please, wait.
Sure.
So, by inference with this, even though it is the content of the report, outside the jurisdictions or within the confines of the report, what the report says, it is true that the finance minister, whether directly or indirectly, has a certain relationship with Databank.
But that's a notorious fact.
But why is that a notorious fact?
Because we all live in this country. We can take judicial notice of the fact that Kenny Oforiatta and Databank are like
father and son.
Absolutely.
Good.
We know it for a fact. Okay. But I'm saying that...
So as a result of that,
yes,
doesn't then bring into sharp focus a conclusion that could be made that a conflict of interest situation could arise whatever point or case in point or instances of situation where Databank or any of its subsidiaries or agencies that it has any relationship with could be in a conflict of interest situation if an action is being taken by the finance minister who has an interest in the...
Absolutely. And CHRAJ made those findings and nobody has complained about it. Okay. That there could be a potential conflict of interest. My point is this.
So CHRAJ is not wrong after all.
No, they are.
No, let him finish.
My point is this. CHRAJ itself found that indeed and in fact, there had not been any conflict of interest, actual, not potential,
true,
in relation to the issuance of these particular bonds. But went further to say that because Ken did not disclose his interest in these companies, and I'm saying that that conclusion is flawed because, one, they did not give the man the opportunity to respond to the allegation itself in the first place. They went and took a document that said that Databank is not listed as part of his assets and concluded that because we know or we take judicial notice of the fact that you have been associated with Databank for the past 30 years and do not find it on your assets declaration form, you have failed to disclose. I'm saying that they could not have arrived at that conclusion until they give him an opportunity to indicate that, yes, I'm still a shareholder of Databank, or that on so and so date, I actually, in fact,
reassigned.
Absolutely. And that this is the register of members which conclusively proves that I have ceased to be a member of Databank and accordingly was not required to put it in my asset declaration form. That's the point.
May I?
Yes, you can.
But small point is that the finance minister...
Be a lawyer.
I am a lawyer.
In this matter.
I am a lawyer and I am speaking as one.
Please.
He got the opportunity to respond to the petition. Indeed, the petition would have been referred to him with a cover letter. He responded and his response is in the public domain.
Yes.
All right?
True.
Now, my brother is further saying that when these facts are established, they ought to have recourse to the finance minister for a further response on the matter. And I am saying it is not necessary. because the tenor of the petition is that you have been cited for being in a conflict of interest situation. So in responding, in fact, you have the opportunity to have filed
in that initial.
Yes, to have filed a further response. If you realize how the matters were being discussed. So you could say that indeed I am associated with all these companies, but I have seen so and so and so date, divested myself and all other entities associated with me with this ones.
But that's what I'm saying, that issue of...
But you say that because there was not a further,
did not arise.
A further opportunity. And I'm making the point, and indeed, it is a legitimate one. How would you be making a case or interrogating a case of conflict of interest situation with me if you don't look into interest that I have in properties, whether incorporeal or corporeal?
What is that?
Whether real or non-real.
Good.
Whether landed property or interest in businesses.
Incorporeal.
Don't worry me this morning.
Yeah, I have to because we're speaking to laymen.
Yeah, so I am saying that it falls within their mandate to be able to interrogate these matters. I can understand his concern that he ought to have been given a second opportunity.
Hearing.
To respond.
So you're not denying
it's
that?
It's not about hearing.
You're not denying that?
He has been heard.
But you are saying it's not.
No,
it was not necessary.
He has been heard.
It was not necessary.
No, he has been heard because he has had opportunity
In respect
to
of this,
respond.
But the second one wouldn't have been bad.
I
mean, to put it in my small plain language.
And indeed, he responded through lawyers. That is what is even important.
All right. Do you find that in the court of public opinion, perhaps your position that CHRAJ may have veered off, and indeed, if that is your position, then it means that it did. And so those, perhaps those matters that you thought were immaterial to what it should have undertaken per the petition, perhaps in the eye of the voters, the public, etc., doesn't give a very good account of the image, the integrity of the finance minister. Does it worry you as a party, as a politician, in relation to the integrity of the finance minister and how he may have acted per those extra issues that were not within the confines that CHRAJ should have investigated? Do you get my question?
Yes, I do.
Great.
And yeah, it worries me.
No.
Because
so it's not possible. That's why you may be acting that.
Wait. It worries me not because I believe the findings of CHRAJ.
That's not the question I asked.
No, wait.
I'm not
wait.
saying.
But the impression that has been created out there that the man did some untoward act or breached some rule or law in the issuance of the bonds, because that is an erroneous position. But because it found itself in the report, it's giving our political opponents ammunition to go out there and propagate it. And that's worrying to me. And particularly so when people's image is at stake. And also the fact that he sitting here, and I know him quite well, he knows the truth. He knows the boundary that CHRAJ breached. That, of course, for political purposes, they will harp on it. And, you know, this country is largely driven in terms of corruption and all that.
It's almost like you want a plate of beans and then they added plantain.
And so, well,
so you have to feast on the plantain.
Well,
I mean, beyond the issues of law, but what's wrong with that?
Well, they can go ahead and do it, but it behoves on us to explain to our cherished viewers that, look, separate the wheat from the chaff.
All right.
Let's deal with the wheat and then deal with these matters as chaff.
Okay.
For which
I disagree that there's a chaff. They are all grains.
Oh, please.
Now let's move on. Government apparently has just announced that is now going to pay contractors and consultants, meaning that contractors and consultants that work with government on its projects with MMDAs, etc., electronically. And we know that the 2016 Auditor's report gave the general public an insight, and this has been reported widely by the mainstream media, that, for example, some liabilities of 1 billion there been arrears or payment that needed to be made to contractors had been left by the previous government. I mean, just so to speak.
1.2 billion.
Okay.
Yeah.
And then after an audit process, the conclusion by the Auditor General was that we've gone through their own books, their receipts, their invoices, and their certificates, etc. The conclusion we come is that they actually only needed to be paid half of that amount or thereabout. And indeed, in some instances, some individual contractors or consultants had been overpaid. That is the position of government now. How does that align with the concern that had been raised by a former roads minister, for example, that says that that cannot certainly be true, the position of the Auditor General?
Well, I cannot speak for the Auditor General, and but the fact is this, that every audit process, I believe, will give an opportunity for the auditee, if there's any such thing, to respond to inquiry. It is after all that has been done that conclusions are drawn based on the findings vis-a-vis the responses that have been issued. So I found it strange. And I had my learned senior friend, Inusa Fusini, last night disputing and clearly making emphatical statements to the effect that it was impossible for the findings that the Auditor Generals had made, clearly impugning the integrity of the Auditor General, if you ask me. Because I would have thought that if the appropriate audit process has been followed through and findings issued, because we all live in this country, it is not very common to have people challenge the Auditor General's report that is submitted to Parliament, because before it is finally submitted, it would have been subjected to some critical test. You know, people would have been given audit inquiries for them to respond. They will cross-check, go through, send them their draft reports. If they have further questions to,
opportunity to pay back.
Yes, and all that before the final reports are issued. So assuming, and I do not have any cause to doubt that that process was carried through, I do not have any reason to doubt the Auditor General's findings at all. And if that is the case, then it is worrying. Because we live in this country, we know the leakages and the abuse that public servants and, of course, politicians, of course, invariably all the time is the politicians who take the heat. But
the flag.
Yeah. The loss that it caused to this state through corruption and corruption-related offenses. And so I found it worrying that Inusa had taken that position, that this was impossible. But if the Auditor General is to be believed, and I do not have any cause to doubt him, and of course, I know that he's taking steps as opposed to the past where disallowance and surcharge and all the provisions that were contained in the law were not applied. To apply them to ensure that these funds that have been paid out wrongfully to people are returned to the state. But I think that if you relate it to the process that has been introduced, that is the electronic payments, that would go a long way to, as it were, take out the human element in processing these payments. And so it can only inure to the benefit of the Ghanaian public purse, in terms of long-term present and future protection of the public purse, control, reconciliation, and all that can be better managed when it is done electronically than as pertains now, where people follow manual checks at the controllers department and some of these MMDAs for payment. So I think consistent with the government's own plan in putting in place a lot of electronic platforms to handle some of these things, of the issue at the port and all that. The gift miss has been implemented, of course, during the area. This is an addition to the gift miss system that has been in place, and I think that it can only inure to the benefit of the Ghanaian taxpayer.
Roxanne.
Yes, indeed, this is actually the gift miss system.
Sure.
This is actually the gift miss. It's not a new system, but what they are doing is that hitherto gift miss was centered at Ministry of Finance. All right, but what they are doing now, in fact, my district, South Dine, a team came from Accra and trained them for about 3 days.
So you're saying it's been decentralized?
Yes. In fact, all that, I don't know whether they have notified.
No, but from the story, it says only 54 or so.
Okay, then maybe they are
IGF,
piloting it.
yeah, possibly.
Maybe they are
I
piloting
don't know
it, but
the
they have
details,
come
but
to
it's
South
possible.
Dine. And so the staff at my assembly have been taken through.
Some training.
So, yes, very, 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 detailed training. And so there are a lot of the procurement, almost all the procurement processes are channeled through the give me system. And the challenge they have now is internet connectivity. That is the challenge with it, but I think it will be improved. When that is done, all payments, all transactions are channeled through the give me system. I can understand why Senior Fuseni will want to speak the way he did. He says that, for instance, if Joy FM Multimedia, you procure these seats with an invoice, and the person has raised the invoice for payment, and he's been paid, there is no way your supplier should raise another invoice for these seats. Because when he brings the invoice and you pay him, it becomes part of your records. So you will be keeping it. Unless hypothetically speaking, and that's the way I understand him, unless somebody kept a photocopy of the invoice and somebody authenticates that photocopy saying that they can't find the original, and so they will process again that photocopy for payment. But to say that a contractor who has say worked on N1 highway has raised certificates and is paid again, it is not possible. Because when you raise the certificate and we process and pay you, you cannot raise the same certificate unless a public official somewhere along the chain corrupts the system. That is why he says that he does not see how that is possible, that you pay contractors twice. But if indeed it happens, like it's saying, we are here, a lot of things happen within the public service, civil service space. And it is part of the processes. That is why give means has come to cut down the human interface. Things are done electronically. Indeed, once the paper trail is going through the system, I think they are even giving serial numbers electronically.
And just about 20 hours ago, we had the Association of Road Contractors saying that they may drag certain government agencies to court, Cocoa Board, for example, for citing some of these reasons for not paying some of their projects.
Indeed, they have the right to do that, because we are also of the opinion that if you have assumed the reins of government and you are saying that you are reviewing some existing contracts, it shouldn't take you over a year to do so. It shouldn't take you over a year. I am saying so because you could say that, okay, in the course of the review, you could do so in pilots. You could take some, review it, deal with it. If you find anything untoward, you handle. You let the law take its course. If you do not, you go ahead and pay. But you don't clog the system. You simply don't refuse to pay under the pretext that you are reviewing the contracts. A lot of them are.
What do you mean by under the pretext that?
Why? If indeed there's a review going on, we want to see the report. What does the report say? Who has been cited and for what? Okay. But every time they put out the information that they are reviewing the contracts, they are not issuing any report in terms of those reviews. And the persons who are supposed to be paid so that they too can go and pay their creditors are in abeyance. And the loans, the facilities they've contracted with the banks, interest are accruing in some cases on compound basis. You know, so it's worrying for the contractors.
But it means the government is going to have a lot of litigation on its hands as a result of this.
Well, I hope we don't get there because litigation is pretty expensive, on both parties. So I hope we do not get there. But you know, it is not the case that contractors are not being paid. His Excellency the President during the press conference stated clearly the quantum of payments that have been effected on that.
But they came to deny.
Well, anyway. some, yeah, of course. I mean, the people who deny are clearly people who haven't been paid. So they will say that we haven't been paid. And the president didn't say that I've paid all contractors.
He said it's an ongoing.
Absolutely. So if people deny that, well, I haven't received payment, for me, it's not inconsistent with what the president put out. Because the president was emphatic that, look, we have paid so much, 850 or so million out of 1.2, and that there were some outstanding that is being.
And this is the association, it's not an individual.
No, but of course, the association. Why? If people receive payments, they go and tell the association.
You need to know
when you get your fees, you go to Ghana Bar Association to tell them that you have been paid.
Japa. Why? They don't come out. They don't tell. They don't say that they have paid me fees.
I want to inquire.
Yeah.
There's something that came up here in the studio. There was this association of, is it law students?
Yes. No, it's Association of Law Students Presidents. It's a unique one.
Okay.
You know, all the law faculties have.
They came to the studio and raised some concerns about. I'm told there's is it a bill?
An LI.
An LI that's before you.
Yes.
And it follows a ruling from the courts. Is that so?
Yeah,
it has a certain history.
Yes.
Okay, so just brief me a bit about it, because the appeal they make is to Parliament.
Yes.
Not to.
They appear before our committee. Indeed, I think we are meeting again today.
Yeah.
Or the two of you are on the same committee.
Yes.
Okay, so
he is a substantive member of the committee, and I'm a permanent friend.
You're a permanent friend. Permanent friend means that you are not.
Look, he was there. We were working hard, and then they took him away.
Okay, all right.
But I've remained, and I work with them quite closely.
You know,
so apprise me of the fact.
Yes, briefly, their worry is that the new LI still contains certain criteria for admission to the Ghana School of Law, particularly the examination
and the
interview. And there were a lot other criteria, but initially when they came before the Committee on Subsidiary Legislation, those ones were debated and taken out. But 2 or 3 have survived, the exams and the interview. And so they are saying that if you look carefully at Section 13(1) subsection E of Act 32, the possession of LLB mandates one to gain admission to read the professional program at the Ghana School of Law. Now, the further section mandates the General Legal Council to make regulations to govern
that entry.
No, to govern admissions, to govern examinations, preliminary and final examination. The interpretation, where the worry is, where the cross understanding is, the interpretation they are placing on whether or not the power given to the General Legal Council is in respect of organizing examinations whilst you are a student, not when you are about to enter. A group of people are of the opinion that he has the power to organize exams even concerning entry, that's admission, as well as when you are a student concerning your studies, the courses you take and all, and your final and the bar exams, as well as your call to be enrolled onto the role of lawyers. And the students are of the opinion with their lawyer that, in their humble opinion, the possession of LLB as contained in subsection C or so of that section, it's only the criteria to be admitted. So once you are in possession of LLB from an accredited law faculty, you have the right to be admitted.
If there's a place.
You see, because I know some members, some reps of the General Legal Council appear before the committee.
Because I know the law school cannot admit everybody. Yeah.
The argument they came to make was a worrisome one. They didn't make legal argument. They were making economic and logistical arguments, and it worried me. They are talking about space.
So create a space.
No, yes. They are not citing the law. They are saying they have inadequate space to train, to admit all those large number of students.
That is
the General Legal Council.
For the law school?
Yes,
okay.
They are running the law school.
Yeah, so they are doing that on behalf of the law school.
Yes.
Yeah.
You see, and they are saying that they.
But you went to that school too.
Yes,
and
we entered just out. We were even called to come and fill our admission forms.
Did you write exams and did all?
No, I did not, because at the time, the numbers were not
which
huge. 2002.
Yes.
Why didn't I go to law faculty? Okay, so it means that you didn't go through the current system.
No, I did not.
All right.
Once you left the faculty.
If by inference you make a cursory observation of the submissions or the concerns of the students and their lawyer, do they have some grounds to grumble, so to speak?
Well, I guess so, and I guess that the General Legal Council also has a point, because yes,
I don't get you. The students have a point, and the General Legal Council has a point.
Yes, that's the interpretation we speak.
It's a chicken and egg situation.
Yes.
You get what I mean?
The situations are what?
See, what I get the students to be saying is this: that so long as we have the LLB, you need to admit us. But the law also mandates the General Legal Council to make arrangements to admit students.
That they can.
Of course, that they can. Because that's the interpretation that they have put to it. That, yes, we ought to interpret the law in a purposive manner.
Okay.
If
we have to
50,000 people qualify, have LLB, or even 10, because 50 is out.
You're afraid your profession.
5,000. No, it's not a matter of fear of the protection of the profession. It's the ability to accommodate. Look, people write SSS exams. When you have 5 GCE or SSC exams, you are qualified to go to the university. But are they? Did they take all the students?
Not everybody.
Absolutely.
Okay, but let me ask this critical question. The law school, as it was when you were admitted as students and ultimately got enrolled, has anything changed in terms of infrastructure to you?
Yes, there has. I mean, now there are 3 campuses. There's a campus in Kumasi, there's a Makola, the traditional place that we all went, and then there's the Gimpa one as well.
For you, that's enough?
No, of course, I mean, I think that there's room for improvement, but look, let's not prejudice the outcome of the committees.
No, we're discussing an issue. We're not saying that because you are a permanent friend and he's a member.
If I may help, what the General Legal Council has done as a result of time, the expansion
as time has,
as the population increase, is that they have moved some of the academically oriented programs, like company law, like taxation, and others,
to the faculty.
To the faculties. So now, when you enter the faculty, apart from obtaining the LLB, the faculties have been mandated to do part 1, what we used to call part 1. So now, when you come to Makola proper, you only do the final part, and then you go.
That is how many years?
That is a year. Okay. And so they are bringing a lot of innovations in there.
And you are saying that that should suffice?
No, I agree. Right. I agree. But I'm saying that the students have a point. They must be listened to. I would prefer a draft lawyer to a non-lawyer any day.
Right.
So we need more lawyers.
Yes. A draft lawyer to a non-lawyer.
Yes. Yeah. Once the person is a trained lawyer,
okay,
the skills that you
I have to end this.
No. You cannot poison the system.
I have to end this. But the last question I have then, because I have to do something, is what pertains in other jurisdictions? Let's say in America, do they also have a General Legal Council that does all these?
No, in other jurisdictions, in fact, you are trained at the faculty, and then you do your pupillage in a recognized chamber. Then you come and write the bar.
Oh,
in fact, what is happening now?
That's not entirely correct, because if you go to America, there's the law school admission test.
Yes,
you do your degree.
No.
Then you do
yes, that is the faculty.
And then you go into the law school and train them after.
You do the JD. You write the bar.
No.
What I'm saying is,
hold on.
What I'm saying is that the situation as it is in Ghana now is pushing a lot. I know a lot of friends who have gone to Gambia. Rwanda has changed from the civil law system to the common law.
So if I want to, I should go to Rwanda.
They are going to Rwanda. A lot of people
I should go to Gambia.
Gambia, Rwanda, and I think Sierra Leone.
Which other country? Gambia, Rwanda.
Sierra Leone.
Okay.
I know people who have gone to Sierra Leone, and within 1 year they are back. They'll come and do the post-call, and then they are called.
So that's the way they are bypassing.
Yes, the frustration is become because the entrance exam is become
it's okay. Don't say that word. Let me save you.
You are doing.
All right. So
in Parliament,
I have I've had rocks and nails in the farm. But will you be going to your constituency this weekend?
Yeah, it's tomorrow.
And he's a member of Parliament for South Dying. I have it on the prompter, so I remember all the time. North Dying.
Regards to Peki Kwebe Kwali Tongo, my people.
North Dying, South Dying. Okay, who is the member of Parliament for North Dying?
Jocelyn Tete.
Does she talk?
Yes, you need to invite her here.
Really?
Yes.
Okay.
I'll tell her.
Andre Japab Mesa is member of Parliament for 2nd D. He's also a lawyer as well. Thanks for joining me, gentlemen.
So it's a pleasure, my friend.
Yeah, they argued.
And we've done a lot of battles at the bar.
Yeah, they argued and became friends at the end. But that's the politics of it.